Did you know that in 1924, the US passed an Immigration Act of 1924, which set to restrict national origins quota specifically designed to limit immigrations from Africa and Asia to near zero? Now, that law was not subtle about its intention. The quota for the entire continent of Africa was just 1,200 people per year, the entire continent combined. It took 41 years and the blood and the sacrifice of civil rights movements before the law was finally replaced in 1965 with a system that was supposed to judge immigrants on their skills and family ties, not the continent they were born in. 100 years later, history is repeating itself because we start paying attention. The US government maintains nearly 50 fully functional embassies and consulates across the country, the continent of Africa. For decades, these sites functioned as direct diplomatic gateways, handling the essential legal processing for students, families, and professionals seeking visas to travel to America. But this week, an internal memo leaked to the press reveals a sudden structural shift that effectively closes doors on millions of people trying to enter the US legally. The State Department just announced it's slashing visa processing across Africa, nearly 50 embassies down to just 20 this month, without no specific date and no warning. It is an operational retreat from the entire continent. Stay with me, subscribe right now, hit the notification bell. New immigration and policy update every Monday. So let's look closely at this exclusive, deep, troubling report confirmed by the Associated Press. The State Department is preparing to rapidly scale back personnel and completely strip visa granting authority from 30 regional embassies across Africa, consolidating all operations into just 20 specialized hubs. There was a State Department directive officially approved by by the Secretary of State Mark Rubio, revealing that the mechanical layout of the shutdown under these new guidelines, if you are a citizen of a non-hub country such as Nigeria, Kenya, and dozens other, your U.S. local embassy will remain physically open, but it can no longer process or grant you a visa. What that means is you will now be forced to pay thousands of dollars out of pocket to secure international traveling, lodging, and transit just to travel across borders to one of the 20 designated regional hubs for the standard visa interview. These 20 remaining hubs include locations like Lagos, Accra, Kampala, and Dar es Salaam. But federal data shows that the wait time of these sites are already completely backlogged, with students in Ghana and Tanzania facing up to 4 months, if not years, just to secure an appointment. Now, when you combine this massive consolidation with the administration active travel ban of the 29 African nations, what you're looking at is a near total administrative shutdown of Africans' access to the US. Just like in 1924, they don't have to ban you by name if they make it logistically and financially impossible for you to ever cross the threshold. It targets students, professionals, and families who are doing everything entirely by the book, pricing them completely out of the legal process. While the State Department seals off physical borders, the White House just signed an operational policy change that strikes directly at the financial heart of immigrants, business owners, and international supply chains here at home in the U.S. On June 3rd, the administration officially issued Executive Order 13781 titled Strengthening Customs Enforcement. This directive orders the Department of Homeland Security and Custom and Border Protection to implement the most aggressive sweeping overhaul of U.S. import regulation seen in over a decade. If we were to translate that into legal plain language for us to understand, the order places intense disclosure and asset restrictions on anyone classified as a foreign entity, which explicitly includes any business owner who is not a U.S. citizen or a green card holder. Under this new framework, if you import goods into the U.S. to run your business, whether it's textile, technology, or consumer retail, you're now legally mandated to maintain a high level of minimum tangible assets inside the U.S., secure massive new continuous custom bonds, and hand over your complete beneficial ownership and business affiliation records to the feds. If you are a non citizen entrepreneur relying on foreign supply chains, the financial entry just doubled for you. CBP has been ordered to purge the importers registry and aggressively revoke importing privileges to any entity that cannot instantly meet these strict corporate requirements. It is a massive economic squeeze disguised as trade compliance, intentionally designed to restrict international trade pipelines run by immigrant entrepreneurs. Subscribe to our channel right now as we try to strip away the complicated government text so you can exactly see what's happening, what policy change impacts your wallet and your legal security as an immigrant or as a citizen job alike. And let's keep moving. Now, before we close, there is a critical development inside the federal government framework that will directly impact how immigrant cases are decided in this country. The U.S. Supreme Court has officially sided with the administration in a high-stakes legal battle over what federal immigration judges are allowed to say in public. In an unsigned summary ruling, the consecutive majority reversed a lower court's decision that had previously protected the free speech rights of these judges. Now, this case dates back to a strict agency policy that explicitly bans immigration judges from participating in public speaking engagements like university panels or media interviews where they discuss agency programs or anything directly related to their official judicial duties without explicit prior approval from government supervisors. Now, the National Association of Immigration Judges sued, arguing this policy directly violates their First Amendment protections and bars the public from hearing the truth about court backlogs and due process failures. The Supreme Court wiped out the judge's lower court victory, letting the speech restriction remain fully in place. This means the very judge tasked with deciding the fate of asylum seekers and deportees have an absolute federal gag order placed on them. They cannot publicly blow the whistle on broken system. They cannot critique the fairness of the fast-track deportation process proceedings being mandated from Washington. When a judge inside the courtroom was stripped of their voice, the individuals standing before them lose their last line of transparent defense. We have systematic realities of an era where institutional guardrails are being dismantled one by removing visa powers from 30 African embassies. They stop the legal pipeline of people before they even enter the plane. By enforcing aggressive assets and bond rules on foreign importer policies, they squeeze the financial independence of non-citizen business owners already here. And by silencing immigration judges, they ensure that systematic flows inside the machine stays completely hidden from public scrutiny. The question today is when the legal system, when the legal gateway are systematically dismantled from the inside out, how can we protect the future of our global communities? Share this briefing with someone who needs to understand the real legal landscape. Drop a comment below with your thoughts on these embassy closures. Subscribe, hit the notification bell. I leave you in the care of Allah subhanahu wa ta'ala. Assalamu alaikum.